In the waning light of 1945, Europe's landscape stood scarred and transformed. Cities reduced to rubble, nations divided, and a shocked world grappling with revelations of atrocities that defied comprehension. Amid this devastation, a group of German officers found themselves in American custody. Men who just months earlier had commanded armies and directed operations across the European theater. These weren't ordinary prisoners. They included Wehrmacht generals with decades of military service, administrators who had overseen occupied territories, and officials whose signatures appeared on orders that affected millions. Their capture had come in various ways. Some surrendered formally as their sectors collapsed, others were found in civilian disguise, attempting to evade detection, and a few had been actively tracked by specialized Allied units, tasked with apprehending high-value targets. As they were processed through detention facilities, the reality of Germany's absolute defeat settled in their consciousness. But another anxiety loomed larger. What would happen to them now? In hushed conversations between cells, a consensus formed among many. They expected no mercy. "The Americans will make examples of us all," one general reportedly told his aide. "We've seen their anger at the camps. They'll want revenge, not justice." This expectation wasn't unfounded. As Allied forces had liberated concentration camps at Buchenwald, Dachau and Bergen-Belsen, American soldiers had witnessed horrors beyond imagination. General Eisenhower himself had ordered documentation of these atrocities, stating, "Get it all on record now. Get the films, get the witnesses, because somewhere down the road of history, some bastard will get up and say that this never happened." The American public, having sacrificed over 400 Gussian lives and endured years of rationing and worry, harbored deep resentment. Newspapers published photographs of death camps, and returning soldiers shared stories of brutality they had witnessed. Polls showed many Americans favored harsh, summary justice for German leadership. Against this backdrop, the captured officers were transported to secure facilities. Some would eventually face trial at Nuremberg. Others, at subsequent proceedings, focused on specific military units or occupational administrations. During transport, they remained isolated from news sources, further fueling anxiety about their fate. Hey, I know we're deep into this historical moment, but I wanted to take a quick second to ask you to hit that subscribe button if you're enjoying this documentary series. We put a lot of research into bringing these lesser-known historical moments to life. Also, drop a comment letting us know where you're watching from. Our team loves seeing how far these stories travel. Now, back to those tense days of 1945. Meanwhile, behind the scenes, American legal minds were engaged in intense deliberation. Justice Robert Jackson, on leave from the Supreme Court to serve as chief American prosecutor, argued forcefully for procedural fairness. "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow," he wrote in a memo to President Truman. This philosophy wasn't universally embraced. Some military leaders preferred swift military tribunals with limited rights for the accused. Others privately advocated for political solutions rather than judicial ones. But gradually, a framework emerged, one built on American constitutional principles and enhanced by international legal standards. The selection of judges and prosecutors reflected this commitment to legitimacy. The Americans chose individuals with impeccable legal credentials rather than those with personal grievances against the German regime. Facilities were prepared with attention to proper court procedures. Translation systems, evidence management protocols, and accommodation for press coverage. As the German officers were informed of the impending proceedings, many remained skeptical. They had witnessed the collapse of legal norms in their own country and expected victors' justice. Some prepared defenses based on superior orders, while others planned to challenge the very legitimacy of the tribunal. "They'll hang us regardless of what we say," one former general told his appointed American defense counsel. "This is theater, not law." The defense attorneys, American military lawyers assigned to represent the accused, faced a complex task. Many had fought against the very forces these officers had commanded. Some had liberated concentration camps or lost friends in combat. Yet professional ethics demanded zealous representation of their clients. In preparation for the trials, American investigators gathered thousands of documents, military orders, meeting minutes, correspondence, and organizational charts. Unlike many historical war crime prosecutions, these cases would rely heavily on the Germans' own meticulous record-keeping rather than primarily on witness testimony. As the trial dates approached, tension mounted. The accused were measured for civilian suits. Replacing their military uniforms, they were given access to legal materials and time to consult with their defense teams. Guards reported observing a range of emotions, from defiance to resignation to occasional moments of apparent remorse. The world watched as courtrooms were prepared. Would these proceedings demonstrate the rule of law, or would they merely provide a veneer of legitimacy to predetermined outcomes? For the German officers awaiting trial, the answer seemed obvious. They expected rage in the courtroom, a controlled but unmistakable channel for Allied vengeance. They could not have anticipated what was about to unfold when the judge entered the courtroom and called the first historical case to order. The cavernous courtroom fell silent as the trial commenced. For the German officers, who had been brought to stand accountable for their actions during the war, the setting itself was intimidating. High ceilings, armed guards at every doorway, and rows of spectators whose gazes bore the weight of a world seeking justice. The Palace of Justice in Nuremberg, partially damaged during Allied bombing raids, but deliberately chosen for its symbolic value, had been transformed into the venue for what would become one of history's most significant legal proceedings. Judge Robert H. Jackson, on loan from the U.S. Supreme Court to serve as chief prosecutor, had worked tirelessly to establish the legal framework for this unprecedented trial. But it was the presiding judge, Francis Biddle, former Attorney General of the United States, whose measured approach would soon surprise the defendants. Unlike the summary judgments many German officers had witnessed during the Third Reich, Biddle insisted on meticulous adherence to legal procedure. "The wrongs which we seek to condemn and punish have been so calculated, so malignant, and so devastating," Jackson declared in his opening statement, "that civilization cannot tolerate their being ignored because it cannot survive their being repeated." The prosecution would seek justice, not vengeance, a distinction that initially seemed meaningless to the German defendants. Colonel General Alfred Jodl, former Chief of Operations Staff of the Armed Forces High Command, leaned toward his attorney during these proceedings, whispering, "This is theater before they hang us all." Similar sentiments circulated among the defendants. They had expected a show trial, a formality before predetermined executions. What unfolded instead left them increasingly bewildered. The first sign that this was no kangaroo court came when Judge Biddle sustained objections from defense counsel regarding the admissibility of certain evidence. The prosecution must establish proper foundation and authentication for these documents, Biddle ruled, dismissing evidence that failed to meet evidentiary standards, even when that evidence would have damaged the defendants' cases. As days stretched into weeks, the German officers watched with growing astonishment as their defense attorneys were granted full opportunity to cross-examine witnesses, challenge evidence, and present alternative narratives. The defendants were provided with headphones delivering real-time translations in German, an unprecedented technical achievement for 1945, ensuring they understood every word of testimony against them. American military personnel in attendance sometimes showed visible frustration at what they perceived as excessive accommodation of the accused. One army captain was overheard muttering, "Why give these monsters a chance to speak?" But Biddle remained resolute in his commitment to due process, once admonishing the gallery, "This courtroom will maintain decorum consistent with American judicial standards, regardless of the defendants before us." The evidence presented was nonetheless damning. Documents bearing signatures of the accused outlined deportation plans, execution orders, and systematic brutality. Witnesses recounted atrocities in vivid detail. Film footage of concentration camps reduced even some defendants to shocked silence. Yet throughout, Judge Biddle insisted, "The evidence alone will determine guilt, not emotion or public sentiment." The defense faced enormous challenges. Few American attorneys wanted to represent Nazi officials, and those who did received threats and public condemnation. Yet the court ensured these lawyers had access to necessary resources, time to prepare, and protection from harassment, fundamentals of the American justice system that were extended even to these most reviled defendants. When Hermann Goering attempted to dominate proceedings with political speeches, Biddle firmly but fairly limited his testimonies to relevant facts, while still allowing him to present his defense. "This court acknowledges your right to speak in your defense," Biddle told him, "but not to use these proceedings as a platform for ideology." Media coverage in American newspapers reflected divided public opinion. The Washington Post praised the remarkable restraint and judicial temperament shown by the court, while other publications questioned whether such procedural fastidiousness was appropriate for history's greatest criminals. Letters flooded government offices from American families who had lost sons in the war, some demanding swift punishment rather than lengthy trials. A pivotal moment came midway through the proceedings when defense counsel presented evidence that certain orders had been issued under duress, with execution as the consequence for disobedience. The prosecution team urged the judge to dismiss this irrelevant context. After careful consideration, Biddle ruled the defense may present evidence of coercion as it relates to individual culpability. This court will examine each defendant's actions within their full context. This ruling sent murmurs through the courtroom and shock through the defendants' ranks. Field Marshal Wilhelm Keitel turned to his attorney with visible disbelief. "They are actually allowing us to explain," he remarked quietly. The technical legal challenges proved immense. No precedent existed for trying leaders of a sovereign nation for crimes committed in wartime. The prosecution had to establish not only that atrocities occurred, but that these specific individuals bore responsibility, a concept of command responsibility that would later become foundational in international law. As Christmas 1945 approached, with the trial continuing through the holiday season, Judge Biddle permitted religious services for the defendants. This small gesture of humanity, extending even to men accused of inhuman acts, embodied the principle that justice, not revenge, was the court's purpose. By early 1946, as the defense began presenting its case in earnest, even skeptical observers noted the scrupulous fairness of the proceedings. The defendants, initially certain they faced a predetermined fate, began engaging more actively with their counsel. They had expected rage in the courtroom. They found instead the cool deliberation of law. Admiral Karl Dönitz, former commander of the German Navy and briefly Hitler's successor, later wrote in his prison journal, "I expected American vengeance wrapped in legal language. I have instead witnessed something I did not believe existed, justice that applies even to the defeated." As the prosecution prepared its final arguments, the defendants braced themselves for the verdict that would determine their fates. Whatever the outcome, they now understood it would come not from hatred, but from evidence weighed according to legal principles. A revelation that would have profound implications for international justice in the decades to come. In the weeks that followed, As the prosecution and defense presented their final arguments, a transformation became visible in the German defendants. The rigid military posture they had maintained since the trial's beginning had softened. When Judge Francis Biddle delivered one of his most significant rulings, rejecting prosecution evidence obtained through questionable interrogation methods, several officers exchanged glances of surprise. The standards of American justice cannot be compromised, even when dealing with those who showed no such restraint, Biddle stated firmly for the record. This court will not accept evidence where duress cannot be ruled out. This ruling, which eliminated potentially damaging testimony against Field Marshal Albert Kesselring, stunned the German officers. Colonel General Alfred Jodl was overheard whispering to a fellow defendant, "They actually mean what they say about fair treatment." As the court moved into deliberations, the Allied judges sequestered themselves for nearly 2 weeks. Inside the deliberation room, heated debates unfolded as the panel wrestled with questions of individual responsibility, chain of command, and the legal distinction between following military orders and committing war crimes. Judge Biddle insisted on evaluating each defendant individually, rather than issuing blanket judgments. "We must remember," Biddle told his fellow judges during a particularly tense discussion, "that we are establishing precedent here. How we conduct ourselves will influence international law for generations. History will judge not just these men, but how we judged them." Nay. When the court reconvened for verdicts, the atmosphere was electric with tension. Journalists from across America and Europe packed the gallery. The defendants entered, some visibly nervous, others maintaining military composure. As Biddle read the verdicts one by one, the complexity of the judgment became clear. Not all defendants received the same verdict. Distinctions were made based on evidence, level of involvement, and specific actions. Of the 22 defendants, 12 received death sentences, 7 faced prison terms ranging from 10 years to life, and 3 were acquitted. The acquittals particularly shocked observers who had expected universal guilty verdicts. When Biddle announced the acquittal of Hjalmar Schacht, Hitler's former economics minister, audible gasps echoed through the courtroom. Grand Admiral Karl Dönitz, commander of the German submarine fleet, received a 10-year sentence rather than death after the defense successfully argued that American naval tactics had often mirrored his own. When the sentence was read, Dönitz's shoulders visibly relaxed. He had expected the gallows. After the verdicts, several defendants requested permission to speak. Field Marshal Wilhelm Keitel, sentenced to death, addressed the court with unexpected candor. "I came here expecting a show trial and propaganda. Instead, I found justice I did not anticipate. While I cannot embrace my sentence, I acknowledge the fairness of these proceedings." The American press reacted with mixed opinions. The Chicago Tribune criticized the acquittals as soft on Nazis, while the New York Times praised the process as democracy's triumph over vengeance. In a radio address to the American public, President Truman defended the verdicts. "We have demonstrated to the world that America's commitment to justice transcends even our righteous anger. This is what separates us from tyranny." Judge Biddle later wrote in his memoirs, "The easy path would have been to satisfy public outcry for universal punishment. The right path was to apply the law impartially, even when unpopular. This is the essence of American justice." The executed sentences were carried out on October 16, 1946. Those condemned to death were hanged rather than shot, denying them the military honor of a firing squad, a reminder that they were convicted not as soldiers, but as criminals. Their bodies were cremated, and the ashes scattered in the Isar River to prevent any burial sites from becoming Nazi shrines. For the surviving German officers serving prison sentences, the reality of American justice continued to reshape their understanding. While confined at Spandau prison, Albert Speer, Hitler's armaments minister, began writing what would become a critical memoir of the Nazi regime, something unimaginable had he not experienced the rule of law firsthand. The precedents established at Nuremberg fundamentally transformed international law. The Nuremberg principles became foundational to modern war crimes trials, establishing that following orders was not an absolute defense, and that individuals could be held accountable under international law. The trial established the legal framework that would later be used for tribunals in Yugoslavia, Rwanda, and the Permanent International Criminal Court. American legal scholars point to these trials as the moment when American jurisprudence most profoundly influenced global concepts of justice. Supreme Court Justice Robert Jackson, who served as chief prosecutor, later reflected, "We must never forget that the record on which we judge these defendants today is the record on which history will judge us tomorrow." For the German officers who had expected vengeance and instead received due process, the experience altered their view of their former enemies. Wilhelm von Lieb, a field marshal who received a relatively light sentence, later told a prison chaplain, "In defeat, we learned more about American values than we ever understood during the war." The legacy of these trials extended far beyond punishment. They established that even after history's most devastating conflict, the deliberate application of law could prevail over the impulse for retribution. This principle, that justice rather than vengeance should govern even in the aftermath of unprecedented atrocity, remains perhaps the most enduring American contribution to international law following World War II. When Judge Biddle returned to America, he faced criticism from those who believed the trials had been too lenient. His response became his legacy. "If we seek only vengeance, we become what we prosecuted. America's greatest victory was not on the battlefield, but in showing the world that our commitment to justice stands firm, even when tested by the greatest evils mankind has known."